Ladies and gentlemen, the event will now begin. Kelly, please go ahead.
Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, The Benefits of Early Mediation. The path least taken requires commitment. This event is brought to you by Law.com and sponsored by National Arbitration and Mediation. Before we begin, I'd like to first go over some basic housekeeping items to help you use the webcast console throughout this event. This event is completely interactive, and it incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console without having to open a new browser. Just scroll along the bottom of the screen and click on the social networking widget of your choice. If you have a question for our speaker, please enter it in the Q&A widget on your console. We will get to your question either during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so we invite you to please ask away. If we don't get to your question, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So please feel free to change the look and feel of your console as it suits you. Also, this event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. CLE credit is available for attorneys in the approved jurisdictions, provided that you viewed this event live for 50 minutes or more. Participants who wish to receive credits for other states must check directly with their CLE board. Within an hour after the presentation, all attendees will receive further instruction via email on how to obtain your CLE. The CLE code will be announced during the presentation. New Jersey and New York attorneys should be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. Their certificate will be available for download 1 week after the event on December 19th. And now for today's topic and the reason you are all here. The benefits of a successful early mediation are obvious. Disputes can be resolved in a private, expeditious, and economical fashion. It gives a chance to resolve the case early, saving your client or business money in defense costs. Here to explore the benefits of successful early mediation and the means by which parties can jointly work toward resolution of their dispute is Jim Bukowski. Jim is a hearing officer at NAM. His distinguished career spans more than 30 years, with his practice focused primarily on litigation at the trial and appellate levels in the state and federal court systems. He is well known within the New York metro area legal community, having served as lead trial counsel for hundreds of cases in nearly every county and in all 5 boroughs of New York City. So Jim, welcome here today.
Hello, everybody.
And before we dive into today's discussion, we'd first like to gather some feedback from the audience by asking a few polling questions. So let's move along into those questions. The first question we have is, have you ever participated in a mediation? So if you could please make your selection by choosing one of the radio buttons here and hitting submit, and we'll give everyone just a few minutes to make a selection before we go ahead and read out the results. And Jim, how do you find most people answer this? Is there usually general familiarity with mediation, and have people used it at some point in your experience?
Well, I'd say with the more junior attorneys, many have not, especially in a larger firm setting. However, obviously, as your career progresses, you have more and more experience with mediations.
Sure, it makes perfect sense. So let's move forward and see how everyone has answered.
You know what's interesting is that as opposed to trial practice, mediations are an excellent resource or way to train junior attorneys. You're not putting up a first or second year associate in front of a judge, in front of a jury. The associate learns how to be on his or her feet and articulate and advocate a case on behalf of a client. And as it were, nobody gets hurt. And it's a great way for a senior attorney who accompanies the junior attorney to critique in real time, take the junior associate outside in the hallway, say how things are going, and just a great way to get your feet wet in litigation.
That's great, and it looks like a large majority are potentially heeding that advice. We have close to 75% saying that they have participated. That's wonderful.
Okay, and 25% have not, I see. Just to go over the basics of as far as the mediation, what to expect walking in for those who have not done a mediation. Generally done in an office with conference rooms And the parties will first meet with the mediator or the neutral together in one conference room. And the plaintiff, the person bringing the case, articulates or gives an opening statement laying out the pros, most of the pros of their cases. Sometimes they will be forthright as far as what there might be difficulties with the case. And then the defendant gives their opening statement. At that point, the mediator may ask some questions, and then the mediator will then break out. There'll be a breakout room, and the mediator will have a private caucus with one side or the other to get things going. And then things go back and forth where the mediator meets with the parties individually and tries to facilitate a settlement. And after an hour or 2 hours or 5 hours, hopefully the case settles and an agreement is written up.
That's great. Thank you for walking us through that. So let's move on to the second polling question here. And that is it your practice to file a written mediation statement? And Jim, maybe you can speak to whether you find that filing a written mediation statement is something that most people do.
I would say a written mediation statement is hugely important, and I would encourage anybody who is going to a mediation to take the time about a week before the mediation just to put together a pre-mediation statement. I cannot overstate how useful that is for the neutral, for the mediator, to get up to speed before the mediation so that the neutral can hit the ground running. And as far as crafting a mediation statement, you don't want to give the mediator the file. Your file is probably, 1 red weld, 5 red welds, whatever it might happen to be. A concise statement of the factual background of the case, what the plaintiff or the defendant, their defenses are, and then annexing the pertinent records as far as medical records or the pleadings, photographs, whatever the attorney thinks may be useful in helping the mediator evaluate the case. As far as the statement, 2, 3, 4, 5 pages, it doesn't have to be the Magna Carta. But I just feel it's incredibly useful, and I feel like I'm much more effective as a mediator where I have a pre-mediation submission from both sides.
All right, excellent. Let's see if our audience is following that best practice. It looks like the vast majority is 70%, just over 70%, and just over a quarter are not.
And just as an aside, those pre-mediation statements that are submitted by either side do not need to be shared with the other side. So you can, in essence, let your hair down and be more open as far as what you think the settlement value of the case is, and discuss anything you want to discuss in private with the mediator before you even get to the mediation.
Okay, perfect. So let's move on to our final polling question, and that is your practice to exchange the written mediation statement with adversary, or do you ask that it be kept confidential? And maybe here, Jim, are there certain situations where exchanging a statement is ideal and maybe other situations where keeping it confidential is more appropriate?
Well, that goes to another issue as well. One of the roadblocks to early mediation. Many times a plaintiff or defense attorney thinks that they'll be at a disadvantage by starting earlier, or that maybe tipping their hand or showing their cards. I personally think that, and I would encourage litigants to submit confidential mediation statements because it just facilitates discussion. It gets the conversation going.
Okay, let's see how everyone answered this question. Same kind of breakout as the last two polling questions, 70% saying no and 1/3 saying yes.
Interesting.
All right, great. Well, thank you, everyone, for your input on those questions. Your responses will definitely help us to drive our conversation here today. So at this point, I'll go ahead and pass it over to Jim to dive right in.
Thank you. Just by way of background, I'm Jim Borkowski. I'm a practitioner here in New York. I am a neutral for NAM, National Mediation and Arbitration, and I'm been admitted for approximately 33 years as a litigator. I've tried more cases than I can count. Started out as a prosecutor in the Nassau County DA's office here on Long Island, then moved into private practice with a large Manhattan firm, and then started my own practice after that. As far as the types of cases that I've handled, I've worked both sides. I've been an attorney for insurance companies, insurance carriers, defending construction cases, automobile cases, premises liability cases, and where there's not a conflict, obviously. I've also brought cases on behalf of injured parties and property damage cases. My wheelhouse has been construction cases here in New York, the so-called labor law 240 cases. So I've worked on both sides, and I think that's a very valuable resource or background for an attorney to have, for a neutral to have, since both parties want someone who's going to be down the middle, someone who doesn't have a proclivity for plaintiffs or someone who's viewed as being a defense guy. So that's what you want to look for in a neutral. Over the course of my career, typically, let's say going way back to the 1990s, a typical mediation was held after paper discovery was exchanged, after the expense and time of depositions were taken, after motions were submitted and motions were decided, and very, very frequently, mediations were held on the eve of trial. I've even seen, you have the mediation on a Friday, the trial is held on a Monday. That put parties under a tremendous amount of pressure, not only in finding a neutral that everybody was happy with and a mediator that everybody was happy with, but as far as preparing, as far as submitting those pre-mediation statements, which many times went by the wayside. You start your mediation at 5 o'clock in the evening, 6, 7 o'clock in the evening, because the neutral was already booked for the day, the neutral that everybody's happy with, the neutral everyone's comfortable with. So it put a lot of pressure, and it made it difficult to settle the cases, and then they would then go to trial or settle on the courthouse steps. More and more, I'm seeing early mediation. Insurance carriers who are having mediation settlement days, large companies like Dollar Store or Home Depot who have a tremendous amount of cases being brought against them, who have mediation days immediately, settlement days immediately after an answer is filed, just to get things going, try to identify the low-hanging fruit, try to identify the cases which may settle. And it's extremely valuable because the benefits of early mediation, as the slide says, the benefits are obvious. Disputes are resolved privately. And let me just compare ADR, mediation, versus the court system. I've been practicing in the court system for decades. I have great respect for the court system, but there are limitations as far as capacity. There are limitations as far as the court being able to focus on your case and the judge's workload. Mediations are resolved firstly in private. And if you have a plaintiff, for instance, an individual plaintiff who is not particularly sophisticated, a courthouse environment can be very intimidating. Many people have not been to a courthouse in their life, and it makes it very difficult for them to feel comfortable, to make a decision, to speak with their attorney privately. In a mediation setting, you have facilities. You have a conference room, you have a lounge. Here at NEM, we have food, we have drinks, we make pizza, we have cookies, we make everybody comfortable. And I can tell you that seeing the litigants, the plaintiffs, the individual litigants, that really, really makes a big difference as far as their comfort level, and it makes it easier for their attorneys to work with them as well, where they can go into a private room and have a heart-to-heart discussion as opposed to going out in the hallway in a crowded courthouse where you can barely even hear each other. Early mediation, it's expeditious. In New York, more than 95% of cases settle. Many times they settle on the eve of trial, but very, very few cases actually get tried. And I see that more and more. You talk to attorneys, they say, how many verdicts have you taken in the past year? And every year it gets to be less and less and less. In mediation, can be done within a week, 2 weeks, 3 weeks, as opposed to 1 year, 2 years, or 3 years. Not to mention, in the second department in New York State, of Brooklyn and Nassau and Suffolk, it can take 2 years for an appeal to be decided, and then you may be back to square one depending on what the appellate court decides. So there's absolutely no comparison between how quickly and efficiently a case can be resolved through mediation versus the court system. Mediations are also far more economic for both parties. From the plaintiff's perspective, a plaintiff's attorney has to think about the time spent, because most attorneys for plaintiffs are working on a contingency, and hours spent normally the return on investment goes down and down and down as the case progresses. Every court conference that a plaintiff's attorney goes to, they're not getting paid for that. The defense attorney is getting paid by the hour, but not a plaintiff's attorney. Also disbursements as far as court filing fees, disbursements for court reporters, which can run into the thousands, motion practice, having to hire experts. A typical doctor, this may shock people who are in California or Illinois or New Jersey, I don't know, but your typical doctor now to testify for a half day of trial, $7,500, $10,000. With mediation, you can avoid that and resolve the case and make your client much more happy earlier on in the case. Also, flexibility. When you're in the court system, you don't get to pick the neutral. Hopefully the judge has expertise in your particular area of law. The judge may or may not, but you are at the mercy of the wheel of the court assignment system. You may be comfortable or be happy with the judge that you have. You may not be happy, but you have absolutely no choice in the matter. It is what it is, and many times the longer a case goes on, the greater the chance that the case gets transferred to another judge who starts from square one and may read the file, may not read the file. So in in mediation, you get to select your mediator. Every company has its roster of neutrals. You can go through that. You can read their biographies. You can see their area of expertise and pick the person that you want to decide or help facilitate a decision in your case. Courts just don't have that capacity. The most important thing about early mediation and mediation in general is that by mediating, you retain control over the process. In the court system, you have a judge who you don't pick, and then if you try the case, you're really rolling the dice. Jury selection may go well for you. You may have a panel that you're comfortable with, you think is going to see things your way. You may be scared, but you've got, in New York, 6 people who are going to be deciding the fate of your client. Someone is going to win, someone is going to lose. It's a zero-sum total decision by the jury that you may or may not be happy with, and that your client may or may not be happy with you at the end of the process. I've seen cases, multi-million-dollar cases, where you've got 18, 20-year-old kids who are sitting as jurors. Is that the kind of thing that you want? By mediating, you get to pick the pace. You get to pick the control over the process, and it's the parties who decide the case. It's not 6 strangers. You're not rolling the dice. Now, many of the practitioners, I believe, who are listening are New York attorneys, but we also have people from California, people from Illinois, and people from New Jersey. I would like to throw out a question on my end, if I may, and for anybody who's interested in answering, I'd love to hear the answer. In New York, we are beginning to institute in the court systems what's called presumptive mediation, mandatory court mediation of certain types of cases, and I think that's going to be implemented during 2020. I'm curious to know, and I appreciate if anybody could respond, whether or not in New Jersey or California or Illinois you have a similar program. In New York, with the presumptive mediation program, what's going to be happening is the court is trying to identify the low-hanging fruit, the cases that they believe can be settled through mediation, whether it be a court mediator or the parties are also free to satisfy that requirement by going to private mediation. They can, rather than dealing with a court attorney or someone, a special master in the court system, they can go to a NAM or they can go to any other type of private mediation and try to settle the case. You don't have to go just through the court system. And what's happening in New York is that the beginning, after the pleadings have been exchanged and what's called the request for judicial intervention is filed to get the case for a first conference, the courts are going to be requiring both the plaintiff and the defendant to give immediate early disclosure. Let's take, for instance, an automobile accident where there's a $25,000, $50,000 policy. What the courts are going to be requiring is that the plaintiff, right off the bat, exchange pertinent medical reports, exchange an operative report to see whether or not the case meets what's called a threshold requirement here in New York. On the defense side, even before the first preliminaries conference where discovery is scheduled, the court is asking about immediate disclosure of the insurance coverage, primary policy, the excess policy. And the idea is, let's say, for instance, we have an injury which is relatively minor and a policy which is relatively small. The court is going to want to get those litigants in immediately to try to see whether or not the case can be settled, or encourage the litigants to go to private mediation and take care of that. Just by way of numbers, as far as the caseload, I talked about capacity, that the courts do not have the capacity to focus on this many. And I'll give you an example from the mouth of a court attorney within the court system who's a friend of mine. In the 5 boroughs of New York City, there are, in the smaller cases, you have the civil court, and you have the housing court, and you have the small claims court. Every year in those 3 courts in New York City, there are 500,000 new filings every year, 500,000 new cases. I don't mean 500,000 pending cases. There are 500,000 new cases. Courts cannot possibly have the capacity to handle all of that. There just aren't enough judges. There just aren't enough court personnel. So in New York, they're trying to identify the cases, not necessarily the huge construction cases, which may not lend themselves to early mediation, but cases where the issues and the facts are rather straightforward, the policies are limited, and maybe bring the sides together and settle the cases. Now, the title of the program is The Past Least Taken. And in my experience, the primary mindset which prevents early mediation of cases is something to the effect of the practitioner saying, well, it's too soon to mediate. It's premature to mediate at this point. As I said before, 95% of cases settle. And I think it's extremely valuable for the parties to look objectively at their cases and take that leap of faith and see whether or not the case can be settled sooner rather than later, before all of the expenses and all the disbursements and before all the time is expended in litigating the case. Part of that process, the leap of faith, is that the plaintiff's attorney and the defense attorney must be comfortable with their selection of a neutral. As in private life, where a marriage is probably the most important decision you will ever make in your life, in my opinion, picking a neutral that you're comfortable with and that you trust is the most important decision in the entire mediation process. And again, with mediation, you can look at a roster of neutrals. You can ask around to other practitioners, what do you think about John Smith? Do you think he's a plaintiff's guy? Do you think he's a defense guy? Do you think he's down the middle? The most important thing besides expertise. Are they comfortable in working on automobile cases, on construction cases, on premises liability cases? But the most important thing is trust. And I would encourage you that if you don't know a neutral and you want to have a conversation beforehand, with ADR you can do that. You can pick up the phone and you can interview the neutral and see whether or not you think it's somebody that you're comfortable that you can work with. Because trust and being able to confide in a neutral is really the coin in the realm that is going to help settle the case. For instance, I talked earlier about how the mediations proceed, where both sides kind of give their opening statements. Sometimes there's a little bit of posturing. Plaintiff will come in with a demand which is some perceive as ridiculously high, or the defense makes an offer which is perceived as ridiculously low, and everybody gets their back up a little bit. And then you ask the defendant, can you leave the room and speak to the plaintiff? And if there is that relationship of trust, if the plaintiff's attorney knows that you are not going to repeat what is said, that you're not going to even tip their hand as far as where they're going to go, you can have a heart-to-heart with the plaintiff's attorney and say, listen, okay, I had a mediation last week where it was a case which was maybe worth 5 figures, where the attorney demanded $6 million. And it almost shut things down. And so I knew the attorney. In fact, he had been an adversary of mine when I was in private practice as a litigator. And I was able to say to him, listen, are we done here? Because unless you get real here, we need to get you and your client down to reality, to get in the same universe where this case can settle. And we went back and forth between each other, and I still had to push a little further. And again, I knew him, and I felt comfortable saying, listen, where do you want to land on this? in reality, where you think this case should settle. Do you see this as being something in the low six figures? And that's the typical type of conversation that you can have. Or conversely, speaking with the defense attorney privately, there's a big policy. You can say to them, listen, how high do you think you're going to go? And both sides will usually hold back a little. There's a little bit of gamesmanship or liar's poker. But knowing who your mediator is and trusting your mediator, that makes all the difference in trying to facilitate a settlement. Quite frankly, one way I look at early mediation is that there's really no downside to it. The worst that happens is you spend an afternoon and you walk out and the case has not settled, and then you have to go forward and you have to do your depositions and you have to do your motion practice and maybe even try the case. And of course, there's nothing that stops the parties from coming back at a later point where each side is educated as far as the strengths and weaknesses of the case. But the selection of the neutral is critical, someone you know, that you respect, and that you trust. Another tool which is very useful that I find in mediations is what's called a bracketed mediation. And what that is in a typical scenario, such as I discussed before, you've got a $6 million demand, you've got maybe a $10,000 offer, and things look pretty bleak, and each side goes in very, very small increments back and forth, and you get to a point where nobody wants to blink, and they're still fairly far apart, but you have that sense that the case is going to settle. And what a bracketed mediation does is you go to each side and you set unofficial, off-the-record parameters. Nobody's committed. The defendant is not committed to a floor. The plaintiff is not committed to a ceiling. And you say something to the effect of, say, to the defendant, listen, if the plaintiff comes down to X, do you think you could see your way to coming up with Y? And this is all totally informal. There has to be that trust. And you have the inverse conversation with the plaintiff's attorney. If they make an offer that's in this neighborhood, do you think you could talk to your client and see if you can get down to a certain area? And this way, nobody's committed, and it's worked almost every single time that I've used it, as long as you've got the right relationship with the two attorneys. Bracketed mediation can really help bridge mistrust and helps you take that leap of faith. I talked to you earlier about selecting a mediator. I think I covered that. You want to have somebody that you're comfortable with and somebody that you trust. Moving on to the next slide, the business versus litigious approach. Depends on the type of case that you've got. I typically deal with bodily injury cases, whether it be a construction accident or a premises liability, trip and fall, or an automobile collision. And there's a great deal of posturing that goes on versus a commercial case. And commercial cases really underutilized in my experience. ADR, they underutilize the mediation process. The commercial cases much more lend themselves to a business type approach because commercial cases or malpractice cases are document intensive. You're dealing with reams and reams of paper, document reviews, experts, and that's really the types of cases that lend themselves to a business analysis where you're dealing with a corporate client who knows, and you're dealing with professionals who know what the exposure is and who know what a case is really worth. So I think one of the questions was certain types of cases which lend themselves to early mediation. I certainly think that commercial cases should be mediated as early as possible, and it's not done enough, in my opinion. Kelly, for all you out there who are using this course for CLE credits, I believe we're going to be giving out the code now, so please pay attention.
Yes, I'm sure everyone is eagerly awaiting that code. So the code for today's event is EARLY 12. That's EARLY and the number 12. Again, the CLE code for today is EARLY 12. Thanks, Jim.
Thank you. Pre-mediation protocols, and again, it depends on the type of case that you have. We talked about a typical bodily injury case where pre-mediation submission is really important. The facts are generally straightforward. In commercial cases, the parties may want to, after selecting the neutral, agree upon what documents are going to be exchanged early on. They're going to be exchanged early on during the course of discovery anyway. Hopefully there's not going to be motion practice, but each party can determine from the other side, depending on the facts of the case, what kind of documents they need to see from the other side to have the other side evaluate the strengths of their cases. And conversely, each side is going to be asking from the other side documents that they think may help in their defense of the case. So there can be sort of, for lack of a better term, a discovery order, which is entered into by stipulation with the facilitation of the mediator. So then the parties exchange their documents, and then they come in, and you have it's not a mini trial, but it's a quick and expeditious way of going through the discovery process and hopefully resolving the case rather than going through years and years of commercial litigation. In my experience, as far as the time that it takes to mediate a case, straightforward cases might take an hour, might take 2 hours. I've seen many cases, depending on the parties, that could take 4, 5, 6 hours. Commercial cases could take at least a day. In any mediation, as far as preparation, in addition to the pre-mediation statement, it's really important to speak and educate your client prior to coming into the mediation. If you have an individual client, explain to them what's going to be happening. Hopefully they're in a position to make to decide what their bottom line is or what they'd like to do in the case. Really, really important to have the client physically present at the mediation, especially if you have an individual. You can sit down with them, have an eye-to-eye. Also, one of the other benefits of mediation as opposed to the court system is that if things are getting close and one of the parties is having a hard time making a decision, whether an insurance adjuster needs to be spoken to or as far as a decision, or more typically an individual plaintiff, a mediator is happy to sit down with the attorney and discuss the strengths and the weaknesses of the case. Incredibly useful because sometimes the attorneys leave the clients with expectations, or the clients spoke to their neighbor and the neighbor got, exaggerating, but $1 million for a stub toe. And the mediator is in a unique position to say, listen, I don't know what you've heard, but this case, the offer here is this, the offer here is that, and can have an honest discussion with the litigant, with the plaintiff, and answer the questions and see if they're comfortable. Any other poll questions out there? Or are we done? Okay. One thing I've also noticed with insurance carrier settlement days is that trick of the trade. I would encourage anyone who has an adjuster who is going to be participating in the decision-making process, if they're not going to be there physically, that they be on telephone standby, and the mediation be scheduled earlier in the day. Because I've had many, many occasions where insurance companies, many times they work earlier hours. They come in at 7 in the morning and leave at 3:30 in the afternoon. The mediation goes until 4, 5, 6 o'clock, and the decision makers have gone home for the day, and they're not reachable. And we're making progress, and that can be rather frustrating. So if you have a case where there's going to be an adjuster involved, whether you're a plaintiff or defendant, I would encourage you to do it in the morning, just to make sure. There's a question which came in, is there an area of law where you find mediation is underutilized? Well, I would say, surprisingly, some of the smaller cases could be mediated early on. And again, referring back to New York, there are so many cases clogging up the court systems that are worth $10,000, $50,000 settlements. There's really little point in the case being mediated for a year or 2 years or 3 years in the Bronx or on Staten Island, only to have the case settle immediately before trial. And 95% of these cases, as I said, do settle. And the facts are rather straightforward. And with the mediation, surprisingly, many times you have cases that are on the eve of trial, and it's the first time that the plaintiff's attorney has articulated a demand to the other side, which is really amazing. You've gone through depositions, you've had court conferences, you've spent so much time together, and the mediation or on the eve of trial is the first time an actual demand is done. And if nothing else, a mediation sort of forces that issue and forces the conversation to get going. So smaller cases, they're just as important to mediate and to put them away. And the earlier the better, again, because it's more cost effective given the recovery and the amount that's going to be paid on it. An insurance attorney or a defendant doesn't want to be paying more money to the attorney than they're paying in the settlement, because then the attorneys are the ones who win and not the parties. Another benefit of mediating the case that the court systems really don't have the capacity or the willingness to do is that when a case settles, both the parties sign a settlement agreement, obviously including the amount of the settlement and any other terms. But in more complex cases, you've got issues where the defendant, for instance, will want a non-disparagement clause. They will want a confidentiality agreement. And there may be sticking points between the parties that, if not tackled by the mediator, are going to hold up a settlement. Judges don't want to get involved in the nitty-gritty of a settlement agreement. They'll say, give me a Bloomberg form, and that's it. So with a mediator, that can be an essential part of the mediation process as well, to work out the non-disparagement clause, to work out confidentiality, or to tailor an agreement. There might be something else that either of the parties want that can be negotiated in that setting. With the mediation, when a case does not settle, and mediators love to settle cases, their client is not the plaintiff, it's not the defendant. Their client, in essence, is the settlement. My particular practice is that in the case where a matter does not settle, I give each side my cell phone number. And I say, listen, I will not charge you anything additionally. Dan will not charge you anything additionally. I'm going to give you a call or give you an email next week, or you can reach out to me and we can have a conference call. We can keep working on the case if you think that that's worthwhile and it's very valuable. Again, that's not something that's available in the court system. Taking a look at the questions that are coming in. Here we go. One of the questions is, and I'll read it so we're all on the same page, is one of the biggest roadblocks to early mediation is each party's apprehension to act in the absence of a more complete discovery record. This typically manifests itself in one or both parties declaring that one of the parties' case is fatally flawed and that discovery will flesh that out. As a result, the offers tend to be well off base. Any tips on how to move beyond this? Well, that's where I think that it's important that before the mediation, once the neutral is selected, if that is anticipated to be an issue in the case, that there should be a conference call with the mediator where each side identifies the documents that they think are important. Say in a commercial case, you want to see certain correspondence, certain contracts. There may be certain issues that each side wants documents for so they can evaluate it. And the parties can enter into essentially a discovery order that resolves any questions in advance and allows each side to evaluate their case and evaluate the other side's case. So my encouragement to that person asking the question would be, before the mediation, get that hashed out, get the documents exchanged, so this way everyone's ready to go on the day of the mediation. And I think I mentioned this before. One of the roadblocks to early mediation is that each side thinks that there's some kind of secret in the case. I can tell you there are rarely secrets in cases. The other side knows what the issues are, and that's been my experience. So as much, not saying tip your hand and tell them everything, good and bad, but there's advocacy, it's gamesmanship involved. but I would err on the side of disclosure, especially as far as documents. Another question. Do you think more states will adopt New York's policy of mandatory mediation? What are some positives and negatives to states mandating this? Actually, I do think that more and more states will be adopting mandatory mediation, and we're seeing that trend more and more. Going from the 90s forward, more and more states have been doing this. New York's reason is just simple capacity. They have your average judge has 900 cases, 1,000 cases in the New York State court system. I believe the New York State court system just physically cannot handle the caseload anymore. Calendars are backed up. In Bronx County, for instance, once a case is put on the trial calendar, it can take 2 years to get a trial. And if you have a plaintiff who's injured, many plaintiffs need money, that becomes a real problem for your client if you're representing a plaintiff. And defendants know this as well. Defendants know that it may take, from the beginning of the case, 2 years to get it on the trial calendar, another 2 years for a trial, and they know that the client needs money, and they may be making a lower offer than the case is really worth. So that kind of congestion in the court system is to the disadvantage of some parties. Also, it's important to resolve cases if you're an insurance carrier, to get them off your books, to get those reserves taken care of. So yes, because the courts just simply do not have the budgeting and they do not have the capacity anymore, I believe that they will be moving more and more towards mandatory mediation. Another question came in. Thank you. Remaining control over the process is a benefit of mediation. Are there certain cases that are especially important for remaining control, thereby making use of mediation? Well, I've represented insurance carriers and I've represented individuals. When you're dealing with an insurance carrier or a corporate client, you're dealing with sophisticated people. You're dealing with adjusters, claims reps, who have seen everything, done everything. They've usually evaluated their case. Hopefully they're realistic about the value of the case. In personal injury cases especially, where you have an individual plaintiff who's been hurt, many times they have unrealistic expectations. Many times they don't know what the case is worth. Many attorneys, I've learned, do not want to give their client what they perceive as being bad news. They think that it's bad business. They have a hard time saying, listen, you seem to think this case is worth $2 million. The other side is only offering $250,000. And they don't want to say, I recommend that you take it. They don't want to say, and this is why. They feel like they're letting their client down. They feel like maybe their client's going to be mad at them. So in those particular cases, I think it's really important, and I've done this many, many times, where the neutral and the plaintiff's attorney and the plaintiff themselves sit down. And many times the attorney will ask you to do that. They'll ask, how do you want to play this? How do you want to do it? And that's a valuable resource. So sometimes you've got to give difficult news or difficult decision to a plaintiff as far as what you honestly think the fair value of a case is. As I said, that can happen sometimes with insurance companies or commercial clients as well. Sometimes they dig their heels in and they committee the case and it's undervalued. But more often than not, it's really important to get involved where you're asked to do it with an individual plaintiff.
That's great, Jim. At this point, I just wanted to continue to encourage everyone to ask questions that may come to mind. Please, don't hesitate to punch any questions into the Q&A widget on your console, and we will continue answering them as best as possible. We have a lot of engagement so far, so we do appreciate that. The next question that has come through is, if your client has a bottom line number, how close should the initial offer or demand be to the bottom line?
I guess that depends of plaintiff or defendant. I'm a big believer in making a realistic demand as a plaintiff, not the $6 million for a $10,000 case. I think that just shuts down negotiations. And conversely, if you're a defendant, making a nuisance value offer on a case can be insulting to a client, especially an individual client. Having said that, the few times in my career where I thought that it would be beneficial, where as a plaintiff, for instance, I said, this is the number my client needs, we're never ever going to go a penny less, we'll take a verdict before we do that, I've been burned every time. Because practitioners and claims adjusters are conditioned to the lowball offer, their outrageous demand. When you say that my client's bottom line is X, they never believe it because it's rarely the case. So I guess the answer is that somewhere in between is probably the best approach. Plaintiffs benefit and move the process along by making a realistic demand, obviously indicating that there's movement. That's why you're there. It's a mediation. And that's one of the things I say before we break out. They each have their case. One side says something that another may take umbrage at. They get their backs up and you say, listen, we're both here to mediate. I assume that you're both here to talk. And when they say yes, then they've opened up their minds in a sense, and then you break out and you go to work from there. But, yeah, to answer the question, I would say a realistic demand and a fair settlement first offer to get the ball rolling. Otherwise, just poisons the atmosphere.
All right, great. Here's another really good question. Yeah, someone from the audience says here, you mentioned that early mediation has been seen more frequently. Is there something in particular that happened to shift the tide where litigants and attorneys are now realizing the advantages of early mediation?
Could you repeat that, please? I'm looking at another question that popped up on the screen, so I got distracted.
Sure, yeah. So someone's writing here, you mentioned that early mediation is seen more frequently these days. Is there something in particular that happened to shift the tide where litigants and attorneys are now realizing the advantages of early mediation?
I think it's a realization that most cases settle and that there's only a certain capacity in the court system, and mediation is becoming more and more popular as more and more attorneys use it. I can tell you, typically the vast majority of cases that I handle and most mediators handle, they settle. And attorneys like that because they get their clients money, or if they're a defendant, they get to close the file. So more and more attorneys who used to take the litigious kind of in-your-face approach, we're going to take a verdict with this, that's fine if you've got a big case and no one's going to pay, but more and more attorneys are used to using alternate dispute resolution, whether it be arbitrations or mediations, because they want to do the best things for their client to have the best result, and mediation is the way to go.
All right, great. Here's another question. Have you ever seen a procedure in which a mediator actually supervises some early, relatively small discovery before the mediation? Discovery seems to be the biggest obstacle to settlement.
I have, and going back again to if you have a conference call, if one of the parties thinks there's going to be an issue, do a conference call with the mediator, discuss what the issues are, because I can tell you, of all the motions, courts hate discovery motions and generally bend over to the side of disclosure. With a mediator, you can talk it out. The mediator can give his or her opinion as to whether or not where the judge is going to come down. They may be right, they may be wrong, but at least you have that discussion. And parties many times also, once it's hashed out, they figure out a way to make disclosure. So there can be a sort of a discovery conference before the mediation where it's all worked out. With a discovery motion, you don't want to go there. Judges hate it, and you never know what the result is going to be.
Perfect. We do have a handful of additional questions, so we'll try to work through those since we do have some time remaining. Again, if anybody does have any other questions, feel free to enter them. If we don't get to them here, we will do our best to follow up with you and answer them after the event. So the next question from the audience is, you mentioned that mediation is far more economical. Can you expand on a specific situation where significant savings were realized? So maybe a case study or a story that you can kind of put out there.
I can tell you many carriers have the mediation days, and frequently, it's not on the eve of trial. They identify cases, or plaintiffs identify cases that they want put on, and the carrier's mediation day, where the carrier has 6 or 7 or 10 cases put on. I settled a case last week that was settled before depositions. It was very, very straightforward. Liability was clear. The policy was somewhat limited, and it wasn't worth spending thousands of dollars on transcript fees and filing fees and getting an expert and making motions. It was fairly straightforward. If there is a case that's more complex, if there is a case where liability is really an issue, sometimes that's not the case where you're going to have a successful mediation. But I can tell you, you will at least make progress. Both sides will be more educated about the case. Sometimes they come back after depositions and settle the case, but it gets the conversation going. I can tell you, I've in my experience, I've mediated many cases, and honestly, I have never had a mediation which I walked out of there and said, you know what, that was a complete waste of time. I should have been back at the office working on other things. You always learn something at a mediation, especially in early mediation. The worst case scenario is that you learn that your adversary is tough to deal with, your adversary is unreasonable, and that I better get ready for trial. This case is going to get ready for trial. So you size up your adversary, and the mediation is a perfect way to do that, and you're educated as far as at least how they perceive their case, and that lets you prepare for litigation, prepare for depositions, prepare for trial. So an hour or two mediating a case is always time well spent.
Excellent. Well, leading into that, someone else would like to know, is there an area of law where you find mediation might be underutilized?
Well, earlier on I mentioned that I think that surprisingly, the smaller cases, people tend to think that, well, I don't want to pay for a mediator, but it's cheaper than spending the client's time and money trying to recover $10,000, $20,000, $30,000. Spend the time earlier on. It's still worth the expense of mediating a case. There's a hugely expanding area of mediation practice are commercial cases. Many counties in New York State, and I believe in other states, have commercial courts and commercial judges, but again, they just don't have the capacity, and there are wonderful neutrals out there who can take the time. I mean, commercial cases, even more so than a plaintiff's personal injury case or a property damage case, judges do not have time to spend hours and hours that neutral does to really dig in and get down to the granular level and identify the issues and bring the parties together. So those are especially the kinds of cases that lend themselves to mediation.
Makes perfect sense. Here's another great question. Do you, as a mediator, prefer to be able to share the parties' mediation briefs and or arguments with each other, or do you think it's better to keep them confidential? What risks do you think the parties are trying to avoid by keeping them confidential?
Actually, I do prefer that the submissions be confidential, only because it encourages both sides to be more frank. Many times I will get a mediation submission from one side or the other where they do say something to the effect of, admittedly, and then they go on to say that something which is an issue, and they try to address it. But I think it really just facilitates parties to open up and evaluate their cases, both pro and con, and that's the kind of submission that should be private, and people would be much less willing to do that if they see the other side is going to be seeing what they perceive as being the negatives on their case.
Okay, we have time for, I think, one more question we'll try to answer here. What are some potential causes of an impasse?
That's a good question, because this just happened and it made me think. Preparation for mediation is absolutely essential. Some people think, well, I'm not going to trial, but mediations require that you dig into the file. The biggest impasse that quite frankly, is attorneys who are not prepared. Because in a recent case, a plaintiff's attorney made a large demand on a personal injury case, and the defense attorney was prepared and knew about a potential huge Medicaid lien that would have affected the settlement because it would have affected the amount that the plaintiff would have netted in her recovery. Plaintiff's attorney didn't even know that the lien was out there. Defense attorney knew, so that became an elephant in the room, and we couldn't really move past that because the plaintiff then had to go back to the office and follow up with Medicaid or Medicare, and So that's something that they should have known. There's typically a Medicaid or Medicare lien letter, which is sent out to everybody, and because of the lack of preparation, the mediation ended up being busted. We're going to come back, but that was just lack of preparation. And the more you prepare in a file, the more you can objectively evaluate your file.
All right, great. Well, on that note, we are getting close to the top of the hour at this time. So I want to thank you, Jim, for all of your valuable insight here today and answering all the questions that came through. Thanks to everyone in the audience for making the time to join us and for being so engaging with us. Thanks also to Law.com for their support. Just as a reminder to everyone joining us here, all participants will receive an email shortly after this event with detailed instructions on how to receive your CLE when it does become available on December 19th. You will also receive an email 1 week from today with instructions on downloading your state-specific CLE certificate. And also remember, this webcast will be archived so you can refer to it at a later time if you so choose. So with that said, thank you all again, and have a wonderful afternoon.
Thank you, everybody.